Hard cases make bad law. Hard cases make bad law. Why? Because you know what every one of you in this room are thinking? He killed her. That's what you're thinking. He killed her. And if he killed her, he's guilty. You're thinking that.
Yeah.
Whether you're doing it overtly, whether you're doing it subjectively, they didn't beat him, they didn't torture him, they weren't talking to each other. They didn't. Okay. The Supreme Court of the United States held absolutely violated his Fifth Amendment privilege. He walked. Never served a day in jail. Not a day. Well, I shouldn't say that. Through the trial process, they held him, but once he, I shouldn't say, once he was, the decision came down on the appeal, he walked. So during that trial process, he was being held. People were outraged. How can that be? Because he killed her, and we know he killed her because he knew everything about how he did it. He had gone to he told her. It was incredible. The evidence was absolutely incredible. The documentation. He had gone to this roller skating rink looking for a little girl. He had been there multiple times. He spotted her. He knew every Saturday she went there with her, you know. So when Vincent, we were law students at the time when the case came out. And we were sitting there, and I would say that to a student, some of us were extremely liberal, some of us were extremely conservative, but even the most right-wing thinking members of our class were outraged. There was one person who wasn't, and that was our professor. And here's why. And this is our system, and it's very different. Oh, I gotta digress one second. Tom, do you have a right against self-incrimination in Kazakhstan?
I think you have just the right to remain silent.
Yes.
Yeah, I think we have that.
Okay.
We need to double check. I didn't look much into the criminal law, but we can look
Yes,
into the
You do have the concept. Okay, good. Because once hard cases make bad law, absolutely no one disagreed this was a terrible tragedy, a travesty of justice. A killer walked free. But here's the issue. And it's what makes lawyers lawyers. That exception, if an exception had been developed, of using indirect questioning techniques, where does it stop? What's next? And the erosion of rights is always an issue that's of paramount concern on these types of very difficult cases. In this particular case, it was a travesty. It was outrageous. Little girl got killed, and her killer walked free. But when the United States Supreme Court takes up a case like that, unfortunately or unfortunately, it's not thinking about the little girl. It's thinking about the United States Constitution and what rights are you given. So how does that impact tax law? Hopefully nobody's going to be involved in that kind of a case. But here's the thing. When a client comes into your office with a particular problem, and as we get into the case, when we get into civil tax exam, you get a little bit more background and then we can get into it. Certain comments that client will make will have to trigger in your minds questions, issues, strategies, not for today, but a year from now, or 5 years from now, or possibly when you're dealing with a U.S. attorney. That may be one of the strengths of our system. It may also can be one of the weaknesses of our system. So, Tom, everybody got the answer wrong, though, but I may mention that. But, it's a terrible case. But we have very important rights, and if you are a lawyer or a forensic accountant, your responsibility is to represent your client. That's your duty. That's your ethical duty. That is your duty as a licensed professional. And we work in the tax arena. I want to go back to my last comment. My client with the gambling. The agent who had the case, this overwhelmed him. So he brought his manager in. His manager, who was in charge of 8 offices within our region, asked the same question. Just tell me what kind of income it is, and I said, I can't. Then he asked me the following: is it drug related? Now, that statement, is it drug related, suggested something to me. You're not going to learn this in class. You get a feel for examiners, you get a feel for auditors. Sometimes you'll make decisions for your client. There isn't going to be some book, some document that's going to tell you what to do. But when he asked me that question, I interpreted it. I've known the agent, I knew the circumstances, as follows: if it's not drug related, I'm okay with it. That's how I interpreted his question. And at that moment, I could have said to him, I can't tell you. I had that choice. The other choice was to say, I can't tell you what it is, it's not drugs. What do you think I did? Remember, if I say it's not drugs, I have compromised his Fifth Amendment privilege. Because a denial of information is the same as an admission in our system. When the manager said to me, is it drugs? Can you tell me, is it drugs? I had a choice to say, I can't tell you what it is. No, his name was David. No, David, the only thing I can tell you is it's not drugs. That I can tell you. What did I do?
Can't tell you.
The second one.
First one.
First one.
Okay, tell me who said first one? So did you say first one? Yes.
You could have opened the door to the investigator.
Very good point. And then someone said, no, the second one. Yes.
Maybe there is some exception for that question.
You're both right. But I'll tell you what I did, and I'll tell you why. I looked at the agent and I said, David, I can't tell you what the source of income is, but it isn't related to drug or drug trafficking. Could have opened the door, because then the next logical question is, where are you going to get that kind of dough? You're going to get it, you know the expression dough? That's a slang term for money. Where are you going to get that kind of money? Next is going to be gambling, right? So now I've taken this much of an investigation and I've narrowed it. There would be no exception, no legal exception. I absolutely could say, no, I can't tell you. The reason I answered the question, and I was right, that was lucky day, is because my assessment at that moment, based on all the information available to me, my experience as a lawyer, knowing this particular agent, understanding the nuance of his personality, having an idea of the initiatives that the IRS was involved with at the time, and we're going to talk about some of the current criminal initiatives. I answered the question. And the criminal case never saw the light of day. I made the right decision. Because once the examiner, the manager, knew it wasn't drugs, he felt, who cares? Silly, you know, it wasn't involved in an activity that our government is so sensitive about these days. And then return got processed. Some of you are going to be called on to make those kinds of decisions for your client. And that's part of the nuance of exam, of appeal, and litigation. It makes for a very, well, I used to have hair and it was brown, so okay, then you get the picture. It makes for a very interesting practice. But those are the types of decisions your clients expect you to make for them. They don't expect you to make the wrong decision. I might add that. Oh, rule number one of practicing law: get paid up front. Okay, get all your money up front. That way you don't have to, you know. You'd be surprised we don't win every case. We win our share, but clients seem to be much more predisposed to pay your bill if you succeed. Probably makes sense. But I think that the only way you can get to that next level, where you're forced to make a decision for your client that puts your client at some jeopardy, is getting right back to the topic of today, having the technical competence. You've got to know the tax law, you've got to understand the regulations, you've got to know your authority. That's a given. And then once you have that base of information, you then move on to the nuance of representation. One last comment, I keep saying one last comment. We have a concept in our system called double jeopardy. Double jeopardy. If you are tried in a court in a criminal case and you are found to be not guilty, you cannot be charged with that crime again. You only face exposure once. Do you have that concept here, Tom? Yes. Double jeopardy? Yes? Exception in tax law, exception, always exceptions. Federal taxes, I told you there's federal, New York State, New York City, income taxes. You could be tried in a federal case, found not guilty, and still be prosecuted at the state level, and vice versa. Because they're actually not, they're considered different. So you do face double jeopardy. 35 years of practice have never seen it. If the state prosecutes the person first, the federal government does not. If the federal government prosecutes a person criminally, the state does not. Policy, but that's not the law. Any questions? Thank you very much. Yes, sir.
Double jeopardy. For example, new facts emerge after the case is decided.
That's a very good question, and there are some exceptions where there is new evidence, but the evidence would actually have to lead to an enhancement of the original crime, or a new crime, or a new charge. But the very particular charge for the conduct, as a general rule, is still going to be protected. But you're right about new evidence. And what will happen is, it would have to be compelled. Oh. Another thing that influences prosecutions and audits in our country, it's on your point. Resources. Resources. Our government has, every day, this many cases that it could pursue criminally. Let's stay in the criminal arena for a second. They have enough resources, investigators, lawyers, auditors, forensic auditors, accountants, to investigate and prosecute these cases, to do this many cases. That's it. What cases are they going to pick? They're going to pick the ones they're going to win. I mentioned to you, Vincent and I worked together on early on when I moved back upstate. We call it upstate, where we live, north of New York City. And the one case that we were involved in was a situation where the government had decided they wanted to litigate for the whole United States of America a particular point. They were looking for some judicial precedents, court cases, which is another source of authority. Again, your materials are just sort of basic. There are many others. Of course, court cases are. The decision to invest resources to pursue a case is a very difficult decision for the government. They only want cases they want to win. The case that as a general rule, civil cases, government wins 95% of the cases. 95% of the cases that get litigated, that go to a trial, and you get a decision, and they're ultimately appealed, the government wins. 95%. The remaining 5%, about half, not quite half, the government, the decision is split. There's a little bit for the taxpayer, a little bit. And maybe 3% of the time, maybe a little more, taxpayer wins. 3%. Why? Because they only take cases that they're absolutely, that they believe through this process of which cases should we prosecute, what's our evidence, how are, what can we present, how sure are we that we're going to win. Very, very rare for that instance. If there's a case that ends up going to an acquittal, if the government has done their job, they've investigated every way possible. But it can happen where there's new evidence and that could lead to new charges, and yes, you could be charged. Thank you for your attention.
Thank you, Jim. It was really great and capturing. So we have a few minutes break. Anybody needs to use the toilet or something else? Yeah. And I will also, I know that some of you are here from other classes and you would like to get some kind of attendance for your class or bonus. So please now sign up. Sign up now. After this session, there will be one more sign up at the end of the